Labor laws. The laws, application of the laws, legal opinion. Labor laws are those that mediate the relationship between workers, employee entities, trade unions, and the government. Collective labor law relates to the tripartite relationship between employee, employer, and union. Individual labor law concerns employees' rights at work, also to the contract for work. Labor law is legislation specifying responsibilities and rights in employment, particularly the responsibilities of the employer and the rights of the employee. Those differ among jurisdictions. This definition pertains to labor law within the United States.
Labor law. Labor law is a specific component of Social Security law that oversees the relationship between employer and worker. It comprises a series of norms and regulations that dictate the rights and obligations of both parties, ensuring a balance between the two. Labor law only concerns dependent employment in the private sector. It does not apply to the self-employed or to civil servants holding permanent or short-term contracts. Legislation regarding labor law exists at a national level through laws and decrees, at an international level through the International Labour Organization or the Council of Europe, and also at a professional level through collective bargaining agreements. Labor law is a key point of reference. It defines the terms of the start, progression, and termination of an employment contract. It ensures fair working conditions and employee protection. It negotiates labor disputes and works toward their resolution. It regulates union rights. It guarantees that workplace health and safety standards are enforced. It protects vulnerable workers. Labor law is an influential factor in the labor market and in employment, as well as in the economic competitiveness of companies. This is why labor law reform is often such a hot topic in national debates.
The laws. Law is a system of rules that are created and are enforceable by social or governmental institutions to regulate behavior, with its precise definition a matter of long-standing debate. It has been variously described as a science and the art of justice. State-enforced law can be made by a group legislature or by a single legislator, resulting in statutes by executive to decrees and regulation, or established by judges to precedent, usually in common law jurisdiction. How important is the law? Laws protect our general safety and ensure our rights as citizens against abuses by other people, by organization, and by the government itself. These exist at the local, state, and national levels and include things like rules about food safety, the role of law, equality under the law, transparency of law, independent judiciary, accessible legal remedy. Why have laws? 1. Promote fairness. 2. Protect human rights. 3. Help resolve conflicts. 4. Promote order and stability. 5. Promote desirable social and economic behavior. 6. Represent the will of majority. 7. Protect the rights of minors. Labor Code of the Philippines. The Labor Code of the Philippines stands as the law governing employment practice and labor relation in the Philippines. It was enacted on Labor Day of 1974 by President Ferdinand Marcos, and the exercise of his 10 extant legislative powers. It prescribes the rules for hiring and termination of private employees, the condition of working including maximum work hours and overtime, employee benefits such as holiday pay, 13th month pay, and retirement pay, and the guidelines and the organization and membership in labor unions as well as in collective bargaining. The Labor Code contains several provisions which are beneficial to labor. It prohibits termination from employment of private employees except for just or authorized causes as prescribed in Article 282-284 of the Code. The right to trade union is expressly recognized, as is the right of union to insist on a closed shop. Strikes are also authorized for as long as they comply with the strict requirements under the Code, and workers who organize or participate in illegal strike may be subject to dismissal. Moreover, Philippine jurisprudence has long applied a rule that any doubts and the interpretation of law, especially the Labor Code, will be resolved in favor of labor and against management. Legal opinion: it is in certain jurisdiction a written explanation by a judge or group of judges that accompanies an order or ruling in a case, laying out on the rationale and legal principle for the ruling. Public Act of Labor Laws, Section 1. It is the policy this act to eliminate the causes of industrial unrest by encouraging and protecting the exercise by employees of the right to self-organization for the purpose of collective bargaining and for the promotion of their moral, social, and economic well-being. Article 300. Termination by employee. An employee may terminate without just cause the employer relationship by serving a written notice to employer at least 1 month in advance. The employer upon whom no such notice was served may hold the employee liable for damages.
Termination of employment is often difficult for employers to manage correctly. Reasons for considering termination include capacity, where the employee is incapable of completing the job; performance, where the employee is not meeting the agreed standards of the role; misconduct, where the employee engages in a prohibited activity; redundancy, where a role is legitimately becoming obsolete. Regardless of the reason, there are important steps to follow before termination is even considered. The only exception is behaviour so serious it warrants instant dismissal, known as serious misconduct. If the issue is one of capacity, performance, or general misconduct, an employer must give notice in writing and allow the employee time to respond. If the situation cannot be resolved, an employer may be able to terminate employment, but only in accordance with strict rules outlined in legislation, including notice periods for termination and payment obligations. These must be followed carefully to avoid an unfair dismissal claim. To understand more about this complex legislation and for peace of mind about your obligations, contact EmploySure today.
Article 287. Retirement. Any employee may be retired upon reaching the retirement age established in collective bargaining agreement or other applicable employment contract. misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work.